question for you. If you would you raise your hand and stand and ask your question? I may repeat it so that the audience can hear it better, and this is being recorded. So please, any questions? Yes, Mrs. Fuller.
I am curious about knowing the thought of Justice Ginsburg about what would be a further weight of international law in commanding a comparative approach. I am referring to the rule in the interpretation of treaties, according to which rules and articles must be interpreted according to the subsequent practice of the contracting parties.
Yes.
Article 31 of the Vienna Convention on the Law of Treaties. And therefore, I think that one reason for paying due respect to judgments and case law in other states are stronger when there are treaty rules that must be complied with. Because at that point, the way in which the other parties interpret these rules measure the, let us say, strength of the commitment of all the other parties. And I think that this is why there are courts, international courts, the role of which is to interpret the common rules, just to measure what is the practice of the majority of member states. And you made a reference to international law at the start of your speech, Justice Ginsburg. I think that also in the end there may be a reference to international law under this angle that is more commanding than just the look for good ideas or comedy. There is something more than that in my perception.
And the question, and I'm going to sort of shorten it just a little bit, and it's a wonderful question, has to do with the interpretation
Of
treaties between
according to the subsequent practice of the contracting parties.
the interpretation of treaties in accordance with the subsequent practice of the parties to that treaty.
And treaties on human rights, most particularly.
And most applicable to the treaties on human rights.
And United States courts, I think, feel most comfortable when they are dealing with a treaty. And let's take the simple one that so many nations are parties to the Warsaw Convention on International Air Transportation. We do look to the decisions, and we refer to the decisions of treaty partners. So a treaty is considered a contract binding on the United States, and the notion is that treaties should be interpreted uniformly. So we would look to the law of, to the practice in other states. The sad thing that I must admit is that the United States has been very reluctant to ratify international human rights conventions. I mean, it took years until we ratified the Convention Against Genocide. We are parties to the Convention on the Elimination of Racial Discrimination. We are not parties to the Convention on the Elimination of Discrimination Against Women, CEDAW. We are not even parties to the Convention on the Rights of the Child. And that's another area in which I think the Academy can be helpful, is to urge our courts to ratify those fundamental human rights conventions. It's a great sadness to many people because one of the prime movers of the international human rights movement, of the Universal Declaration, of the Covenant on Civil and Political Rights, was a very great lady, Eleanor Roosevelt.
Yes.
My name is Andrea Gattini, and I would like to put a question. A little bit embarrassing putting you this question because it has to do with respect to pay due respect not to the opinion of humankind by the Supreme Court, but respect to judgments by the International Court of Justice. So you were referring to the Venice Convention, and I think there is also a risk that the government, the US government, abused a little bit this argument of saying what other parts of the treaty do, interpreting the treaty. I'm referring to the Medellin against Texas case, where the Supreme Court took an opposite position about direct effects of the Vienna Convention on consular relations on 63, not only despite of what other parties do, but despite of what the International Court of Justice said, expressly said, in the Legrand case and then the Venice case. So my question, I said, I'm a little bit embarrassing in putting you this question because you were one of the judges of the minority in the Medellin against Texas case. I would, just a curiosity of mine, to know if, in that case, the position between majority and minority in deciding the case had to do with due respect of opinion as a matter of comity, or with a specific obligation of US to comply with the decision of the International Court of Justice. And if you see some possibility of a reversal of jurisprudence by the Supreme Court in dealing with not comparison with other Supreme Courts all over the world, but respect to the World Court. Thank you.
And the question has to do with, and it formulates around the Medellin versus Texas decision.
Yes, it would be the focus of it.
Right. The Medellin versus Texas decision in which Justice Ginsburg wrote in the minority. And the idea, and I guess the question has to do with what would be the future, if you will, of the Supreme Court's respect, if you will, for the international courts of justice, in that. And related to the Medellin case, what are the, I guess, odds or chances of that case being reviewed again, or a case similar to it being reviewed, and possibly reversed in that opinion?
Perhaps we should give a little bit of background for people who are not familiar with the Medellin case. The question that arose under the Vienna Convention. The Vienna Convention on Consular Relations has a provision that says if an alien is incarcerated, that alien has a right to contact the consul from that alien's nation. The notion is that an alien unfamiliar with our system might be aided by his or her counsel. That provision was put in the Vienna Convention largely at the urging of the United States because there was a concern that some of our young people traveling abroad, take Turkey for one example, might be thrown into prison and be without means to defend himself or herself. So the United States was a prime mover of that provision. The Medellin case involved Mexico suing the United States before the International Court of Justice. And Mexico's complaint was there are several people, Mexican citizens, who are incarcerated in U.S. jails or prisons, and when they were tried, they were not told that they had a right to contact their consul. And there should be a remedy for that default. When the United States argued before the International Court of Justice, this is the gist of the argument they presented. We have in the United States a famous decision known as Miranda. Miranda was a decision of the U.S. Supreme Court which said that before a person can be interrogated, a person arrested can be interrogated, he or she must be told, you are not obliged to speak to us. If you do speak, anything you say can be held against you. You are entitled to be represented by a lawyer, and if you haven't got the means to pay, the state must provide a lawyer for you. What would happen if a defendant hadn't been given his Miranda warnings, but went through an entire trial, and then, after he is convicted, raises the question of having been denied his Miranda rights? The argument before the court in The Hague was that this is on behalf of the U.S. government, we treat the Vienna Convention provision just as we treat Miranda. If you don't raise the question and you're convicted and your appeal has been exhausted, it's too late. So, if you weren't told of your Vienna Convention rights, and you didn't complain in the trial court and didn't complain on appeal, and the time for further appeals has expired, that's over. So the argument was, we treat these two the same. That was not what the International Court of Justice found satisfactory. Then when it came to the Supreme Court, the court made a distinction between treaties that are self-executing and treaties that are not. And the majority decided that the Vienna Convention on Consular Relations, that the provision for notifying someone who was apprehended of the right to contact his or her consul, that Congress had not passed a law implementing that provision. Therefore, it was not self-executing. There was a very strong and I think totally persuasive dissent in that case. The court divided 5-4, and at least the world can see, I know that our practice of dissenting opinions is not universally shared, but in the history of the United States, so many of the great dissents have become the law of the land. So I think that the Medellin dissent, which I joined, got it right. And my hope is that someday the court will recognize that.
Additional questions? Yes, I see a hand in the back. Professor Newman.
Justice Ginsburg, you mentioned the post-war German Constitution. I believe that much of that Constitution was a specific reaction to the atrocities that happened during the Third Reich, and that in fact one probably can't fully understand that Constitution without that context. I agree with everything you say, and I ask whether you would agree that the notion that courts should accept help from wherever they can get it, including from foreign statutes and foreign decisions, comes with the obligation to do absolutely everything they can do, including getting the help from counsel that appears before them to understand the context of those foreign decisions.
And the question basically has to do with whether or not the court has an obligation to get counsel or information from whatever source, whether it be the counsel that is actively in front of the court itself. And the question has its genesis from looking at the post-war German Constitution and noting how that basically arose out of context and the importance of context in interpreting laws.
I think it's, and please correct me if I'm wrong, but I think the history was the same in Italy, that there wasn't a constitutional court here until the end of World War II. There was a European precedent. I think since the 1920s, Austria has had a constitutional court. It emerged out of the appreciation that democratically or popularly elected legislatures, as it was in Germany, are not necessarily to be trusted to be the sole guardians of human rights, and that's why constitutional courts were set up, so that they could be one player. Now, to be realistic, Austria had a constitutional court, but it didn't stop the Third Reich from, didn't stop the Anschluss, didn't stop the horrors that were committed in that country. It is one means, but certainly it's not the only one. It's not perfect. But for me, it's very interesting to see how this idea has taken hold, and it's not just in the civil law world. Our neighbor to the north, Canada, never had judicial review for constitutionality until 1982, when they got a Charter of Rights and Freedoms. And I will also confess that if you look at decisions of the Supreme Court of Canada on human rights issues, they do tend to refer to foreign sources to a greater extent than the United States Supreme Court does. I think even the UK was the bastion of parliamentary supremacy, but they became parties to the European Convention on Human Rights. And rather than being hauled before the Strasbourg court constantly, they decided that they would make the European Convention on Human Rights, they would incorporate that as part of the domestic law of the United Kingdom. And so now there are ordinary laws, executive acts in the UK will be measured against this European Convention on Human Rights.
One more question? You get the last word.
Well, I have another second question. You spoke of the way you take attention, you pay attention to the jurisprudence of other courts. But I'm sure you are also well aware of the importance of the jurisprudence of the US Supreme Court towards other countries. We all look at the Supreme Court as a, well, let's say as an example, a mentor. So I'm thinking about now, when you have to deal with international customary law, if you are aware of the importance, the impact that your judgments will have on decades. And once again, they are embarrassing in putting this question because it has to do with the pending case, with the Kiev case. And of course, there are many different ways to solve the case, and possibly one would be to stop it, a procedural aspect. But should you go into the merit of the case, the existence of the international customary rule of responsibility for companies for violation of international crimes, what is the way you think about the future which your judgment will have on the state of international law as such, even, because it will be one of the first decisions by Supreme Court in dealing with this fundamental aspect of customary international.
And the question deals with whether or not the justices on the Supreme Court, in deciding their cases, are aware of or keep in their consciousness the effect of their opinions on international customary law and its effect with regard to their decisions that it will have on laws in other countries and on international law.
I should explain the Kiobel case was a case against 3 oil companies operating in Nigeria for alleged complicity with atrocities against some of the people in a region of Nigeria. When the case came before us this year, the question was, is our alien tort statute applicable to artificial beings, corporations and other artificial entities, or does it apply only to individuals? The court didn't answer that question because in the course of the oral argument, one of the counsel suggested that perhaps the alien tort statute doesn't apply to events that occurred outside the United States. And so we have set that case down for re-argument on the question whether a violation of the law of nations committed outside the United States is subject to review in the United States courts. I fully expect that when that case is re-argued, that we will have many friend of the court briefs, some from law faculties, making this very point about customary international law. And I can't forecast how the court will rule on that question. So it will be before us next year.
Wonderful, and with that, please join me in giving a round of applause to Justice Ginsburg.